application in the matter of Magomedov and others and TPG Holdings, SBS, LP and others.
Yes.
Good morning, my lords. My lords, my name is Thomas Kluman. I appear for the applicant, claimant, would-be appellant, together with Moylan Jr. Mr. Robert Steele on the instructions from Celador Limited. And Mr. Steele and I are relatively late replacements for Mr. Sol,
Yes.
who became unavailable and, as you will have seen, had drafted both skeletons.
Yes.
In accordance with the order of Lord Justice Phillips,
Yes.
there is no appearance for the respondents.
Yes. We have documents from them.
In fact, you have documents from them, which
Yes.
I will refer you to. Diving straight in,
Can I just say Lord Justice Phillips' order says that the application to reopen is adjourned to an oral hearing with the application for permission to appeal to follow if the application to reopen is successful. I don't know how you propose to structure your submissions, but it would help us if we first hear your submissions on the first point, in other words, the application for permission to, the application to reopen, and then we will take stock and consider what further submissions or how the case should then progress.
I understand that, my lord, and certainly I'll endeavour to do that. I had noticed that that was what the order was. There is a slight wrinkle in it, if I can put it that way, which is that for purposes of the Rule 5230 jurisdiction, one of the operative questions is whether the decision would have been probably different if
It's an
whatever,
element, yes.
but
I hope you can structure your submissions sufficiently confined to that, to the, as you say, the structure or in the way in which reopening applications are determined, or the issues that arise.
Yes.
In order for the application to reopen to be determined.
Yes, I hope so, and I invite you also to redirect me if I'm transgressing too far on the other side. I had tried to have it sort of summarily in the first part in order to deal with that obstacle, and then in more detail should it be required, but that's absolutely fine.
Thank you.
And your lordships will have seen that in paragraph 3 of the application skeleton, there's an express acknowledgement of both the height of the bar on this application and indeed of the importance that no disrespect is of course intended by any of those who drafted those documents or by us to Lord Justice Magomedov. We do bring an application because we say that there was a failure to grapple with certain key issues and that permission should have been given, but it is brought very much in that respectful way. And your lordships will have received, by way of bundles, I take it, an applications bundle, a core bundle, a miscellaneous bundle, a core authorities bundle,
Yes.
which we're invited to produce,
Yes.
and then a very much larger 9-volume main authorities bundle,
Yes.
which your lordship certainly won't want to spend much of the day.
No, the volume of material
is
is,
enormous.
well, I was going to say staggering,
Yes.
given the nature of the application,
I-
including the original skeleton that was filed
Yes.
in support of the application for permission to appeal,
Indeed,
both too
I'm going to
long
address that
and
too.
too small a font.
Yes, yes, I'm
Yeah.
going to address that too.
And it leads to wood for trees,
It does.
or a risk of wood for trees.
I should make clear, I completely accept that we bring an application in which we contend that Lord Justice Males did not grapple with some key points. I accept that having a mass of material did not necessarily make the selection of the points or the identification of the points as easy as might otherwise have been. And if that's our fault, that's our fault. Lord, as to the approach in oral submissions, cognizant of the order of Lord Justice Phillips, what I'd like to do is get a few procedural points out of the way, if I may, cover a little background, if and to the extent necessary, both procedural and substantive, then address the law relevant to reopening refusal of permission of appeal, so this particular jurisdiction. Then I'll try to capture what the high-level complaint is before drilling into its detail, and obviously it takes two parts because there are two conspiracies that were joined in this claim. And inevitably, there's a huge amount to cover, and I would inevitably like as much time as your lordships give, but I will try to do this efficiently.
Thank you.
May I note this, it is important to say that since the judgment, the claimants have in fact continued to undertake investigations into the events underlying these conspiracies, trying to obtain further material, and if and when they do obtain such material, they would only be able to deploy it if they could bring an application which permitted it to be deployed in an appropriate way. And there is no application of that kind before you today. But it is right to mention that if your lordships were persuaded to reopen and were then persuaded to grant permission on some or all of the grounds, one of the things that might yet happen is applications to introduce additional evidence. And so I do say that by way of frank disclosure, but it does not affect the decision that you have to take today. None of that material has been put before. Just as to the respondents' notices, I gather from your lordship's comment that your lordship have seen them. There are specific notices that were filed by the respondents in response to the application, and they are at tabs 14 to 20 of the miscellaneous bundle. And they were preceded by the usual respondents' notices under the practice direction responding to the application for permission to appeal, and they too are in the miscellaneous bundle at tabs 1 to 13. And obviously, so far as I can and so far as relevant, I will try to pick up some of the points in those notices. But in the nature of that volume of points, I can't say that I will necessarily pick up all of them, but I will try to pick up those that do, in my submission, bear on the decision that you reached. I said that there were three procedural points I wanted to get out of the way. The first of those is that in one of those notices, it happens to be at tab 14, it's the joint FESCO defendants notice in response to this application. There's a point about suggested delay in bringing this application. The relevant dates being that the sealed order for refusing permission was the 3rd of June, and the application was filed on the 10th of July. And that notice refers to some authority to which I don't intend to take you. I'll just tell you what it was about in the Ingenious Games decision. It is in the main authorities bundle, which does say that such an application to reopen, should be issued as soon as possible. And that's the learning on the point. There's no hard rule. In that case, there had been a delay of some 7 months and indeed an intervening substantive appeal hearing, and we would submit in that territory. So I draw the point to your lordship's attention, but I would hope that given the complexity of the case, your lordships would accept that this application was filed indeed as soon as possible. The second procedural point is as to the length of the skeleton that was filed in the application for permission. It's 87 pages, and that's a point specifically identified in some of the respondents' notices. And it needs just a little bit of unpacking, if I may. First, to say, it's not a point which was ever treated as a fait accompli or ignored or anything like it. What had to be done is that the grounds and notice of appeal had to be filed first, and in that notice, permission was sought for a 75-page skeleton. If you need the references, it's core bundle tab 1, page 22, paragraph 60. There was an application for that purpose for an extension of time and for the 75 pages. The extension of time was determined. The question of skeleton length was left to the application for permission itself, and so not decided in advance. And in the event, an 87-page skeleton was filed, but that skeleton, in paragraph 7, apologised for that fact and sought to amend the underlying application for permitting the longer length for reasons which it there set out. And as to that, as to the length of the grounds and as to the length of the PTA skeleton, can I add this? I accept completely, my lord. There are 23 grounds of appeal. and the length of the skeleton makes assimilating the arguments demanding and difficult. But I also submit that the case is a significantly complicated one, that it necessarily involves, as conspiracies sometimes do, many different strands and a large number of defendants. And the grounds themselves, in my submission, are not duplicative, even though they are many. They necessarily address the issues that arose, that serious issue to be tried, gateway, applicable law and forum, and do so against each of the different defendants and under each of the two conspiracies. So we apologise for the length of that skeleton, Lord, and we note, and I'm going to go to what Lord Justice Mayles had to say about it. But that is the explanation that we give. Now, if we then go to the decision refusing permission, that's at Application Bundle, tab 3, page 21.
This is your third procedural point, is it? Or is this still dealing with the
This is the
length
skeleton
of the
length, it's the second point.
Okay.
I wanted to draw to your Lordship's
You would
attention.
have refused permission.
That's right. So at the top on page 21, you see that paragraph 3 records permission to rely upon an 87-page skeleton is refused. And then over the page in paragraph 14, that a reason is given, although I have considered the applicant's skeleton argument. A skeleton of this length is generally unhelpful as it tends to obscure rather than clarify. If I had granted permission to appeal, I would have required a more focused document.
So that made clear he'd considered the skeleton as it was, but as he said, if he had given permission, he would have required a shorter, more focused document.
That's exactly right.
Yes.
Of course, when we then had to bring this application, we could only put before you properly that which was put before the Justice Mayles.
Of course. Yeah, no, don't worry.
So we couldn't
want another one.
Indeed. So we're not simply treating this as a fait accompli. We accept all of that. We also accept that if your Lordships were persuaded to reopen and did give permission on some or all of the grounds, you might also give such a direction. And all of that would be as it was. But we are certainly not ignoring the point, and we ask for your permission to deal with it in that way. The third procedural point is a point made in some correspondence with the court about fair presentation. Your Lordships will know that a core authorities bundle was unsurprisingly required. The request for a core authorities bundle expressly said, as I recall, that even the 19 authorities that were collectively cited by all the parties on the 5230 application was too many. And in the end, what we thought it appropriate to do was to produce by way of a core bundle the specific authorities that go to the 5230 jurisdiction, and that's what you have before you. But that does mean that some of the respondents' notices have referred to other authorities which are not in the core bundle. And a complaint was made about that and suggestion that in the respondents not appearing, that somehow creates a duty of fair presentation. We don't really accept that. You've got the notices. We did what we could to have a reduced core bundle, but I will take you to what I perceive to be the most important of the points in the respondent's notice. I doubt, so those are the procedural points to get out of the way. I doubt your Lordships need me to set out the procedural background.
No. Thank you.
I won't do that. And as to the factual background, I'm not sure to what extent your Lordships will obviously have read the judgment, which sets out quite a lot of the background in paragraphs 50 to 83. And I'm not sure to what extent your Lordships.
Well, we've had some time to devote to this case, so we've read quite a lot.
The only thing I wanted to show you, in case you had not seen it, and you can tell me if you have, my Lords, is that attached to the remanded particulars of claim are two organograms.
Yes.
And the reason they are helpful is that one can locate where everything sits. If your Lordships have seen those, I won't take you to them, but otherwise I will. Perhaps we can just see them at page. So it's
I think they were attached to the judgment.
Well, aren't they annexes to the judgment?
They are.
And so we've read them in that
You've
context.
read. That's fine.
It's Annex 1 and Annex 2.
Yes, and you get. I confess I've been using the versions in the particular claim, which are
Are they different?
360 and 361. I will check for you, but I don't believe. And
Well, they
there's certainly
say the document that we've read says Annex 1, and then on the right-hand side it says Annex 1 to the particulars of claim,
it does
and
indeed.
then Annex 2.
Yes.
They're
So
bigger.
they are the same.
The only difference is that the particulars of claim have, at least the first one in landscape, which has its own advantages if your lordships are in small bundles, but I leave that entirely.
Thank you.
So those organograms do enable one to see where the myriad different parties fit
Yes.
in the greater structure. I also assume then explaining that the outline of each of the two alleged conspiracies is unnecessary. And I turn to the law, if I may, on this rule, on the jurisdiction under CPR 5230. Despite 9 volumes of authorities, the one thing that's not in the authorities bundle is the rule. But your lordships have no doubt seen it. The
Well,
Court
it's
of
set
Appeal,
out in the authorities.
it's set out in various applications,
Yeah.
so it's repeated in various places. The relevant requirements in paragraphs A to C of subparagraph 1 being that it be necessary to avoid real injustice, that the circumstances be exceptional and make it appropriate to reopen the appeal, and that there be no alternative effective remedy. And then subparagraph 2 of the rule makes clear, and obviously there have been judgments on this basis before, that it applies equally to an application for permission to appeal.
Yes.
As to the substance of the jurisdiction, the key principles have in our submission been, in recent years, been restated several times. It's not that they need to be added to. For the most part, it does not seem to me that they are really in dispute between the parties, subject to some small points that I will come to. Everybody's referring to the same cases. I'd like to deal with 5 points, if I may. The first is just the general height of the hurdle. The second is, as is necessary for purposes of this application, what is required by way of decisions refusing permission to appeal. The third is as to the structure of the inquiry. The fourth is as to the injustice requirement, and the fifth is as to alternative remedy, that being the requirement in
What's the
subparagraph C.
fourth one?
The fourth one was the injustice requirement. The authorities, of course, say that it is necessary to show a significant injustice, that being that the decision would have been different, really, but I'm going to come to that in a bit more detail.
The fifth one was.
And the fifth one was the alternative remedy point.
Yeah.
Which is a point raised in the respondent's notices, and I do need to admit. Just as to the height of the hurdle, your lordships will doubtless be familiar, and in any event have seen that the historical authorities generally referred to are the Goring-on-Thames decision and the Wingfield and Canterbury City Council case, but they keep being recited again, and most usefully in our submission gathered in the Mariana decision, the Brazilian Slimesdam case. And I am going to want to just deal with a few contents of that. Your lordships have it in core bundle tab 5, page 86. The quotes from the previous decisions that set out the requirements are really in paragraph 59 and 60, so you'll find that at page 99.
Yes.
Setting out in 59 a very lengthy quote from Goring-on-Thames. While I'm simply referring to it, can I note the reference also within that quote? So the quote within the quote is a quote from Dame Elizabeth Butler-Sloss's decision in Inri Udden, which is a point that is raised in one of the respondents' notices, that authority. And then you get, in paragraph 60, the citation of the list of requirements as set out by the court in the Wingfield and Canterbury City Council case. So we accept, Lord, those quotes establish this is a highly restricted jurisdiction which presents a high hurdle. it requires not merely that the decision was wrong, but that the integrity of the decision has been undermined, and that there is a powerful probability that the decision would otherwise have been different. We accept all of that. Now, before then moving into the nature of the inquiry, can I just deal with reasons for refusing permission to appeal, which has also been the subject of a body of recent authority, and that authority also is most conveniently found in the Mariana decision. And if your lordships go back to page 98, paragraph 54 through to 56, the court set out quotes from the previous authorities. I don't have to go to the previous authorities, but I do include the Wasif and Secretary of State case in the judicial review context, and then the Goring-on-Thames case itself. And the key points to emphasize are those within the quote from Wasif in paragraph 55 in my submission, that the reasons should be sufficient. It's about 5 lines within the quote. The reasons should be sufficient to show with sufficient particularity why permission has been refused. And then further down in the quote, in quoted paragraph 20, in the beginning of the 3rd line, what is necessary depends on the case, but all the claimant's points must be identified and addressed. So those are the 2 points we would say the law establishes are required of.
Yes, but sorry, wait a minute. The first point, yes, sufficient reasons should be sufficient to show with sufficient particularity why
Yes.
permission has been refused. The second, which I've now just lost.
I'm sorry, in the quote from paragraph 20,
Yes.
and then it's the first
yes.
5 lines.
Yes. It's all the claimant's points must be identified and addressed. I don't think one can take that literally.
Obviously, Lord, I accept that where that bites for purposes of this application is that there are cases, and this was one, in which it might be said that there are some issues without success on which the other issues don't matter. So they are, in a sense, critical path issues. And of course, when it comes to the NCSP conspiracy, Lord Justice Mayles dealt only in substance with the fair presentation issue upon that basis. Now, I wasn't intending to ask your lordships to find that that can never be done. And if that's the query on this authority, to that extent, that's not a submission.
No, it was more that if you took literally all the claimant's points must be identified, and I mean, sorry, it is slightly going back to the skeleton.
Well, it is.
There are, I don't know how many points, but an enormous number of points, and it would be surprising if it was suggested that a judge, in refusing permission to appeal, had to deal with all those points, and I don't think that's the submission you're making.
It isn't. It isn't. But certainly, where there are material points which may lead to the result being different, in other words, they may lead to permission and in turn to success on appeal, all of those points should be addressed, unless it is possible to say that the necessity to consider them is dispensed with because of some gateway problem, and that's what we'll come to in the NCSP conspiracy case.
Doesn't it start slightly earlier, as you said, that it's not merely wrong, the decision was not merely wrong, but the integrity of the decision or the process has been undermined? And isn't that what this is going to? The absence or the failure to deal with points must be such as to undermine the integrity. I'm going to call it a decision rather than a process. The integrity of the decision, isn't
I think that's entirely right, Lord. I'm going to come to the way the 2-stage inquiry is described in one of the decisions, which is a helpful place to locate that debate. But I do accept that the probability of injustice is a part of all of this, And that ties to this undermining the integrity of the decision, that being something more than it being merely wrong. But if it can be said that there was a failure to grapple with a ground of appeal, which, had it been grappled with, may have led to a different result, well, that is something which may undermine the integrity of the decision. All these things are also questions of degree. I accept that completely. But that's why I took your lordship to this decision.
Sorry, sorry
Yes,
to keep interrupting. Just, I think you phrased that as a failure to grapple with the ground, which, if it had been grappled with, may have led to a different decision. Is that what you said? We haven't got the transcript.
We don't have a transcript, but I'm perfectly happy to accept that the test in the end is close to a test of probability. It's a sort of loose probability.
Okay.
I do accept that, and the cases say that, and we will see that.
Yeah.
My lord, one may take as an illustration on this the Mariana case itself.
Yes.
Which was an application to reopen permission, and it was reopened, and permission was granted.
Yes.
And what one finds in it is a series of points identified, which it is said that the Lord Justice, considering permission to appeal, had not grappled with, and the court analyses why they really mattered, and concludes that does result in a significant injustice. And so that's our target, if you like. I completely accept that it's a high bar, but what we seek to persuade you is that there was a failure of that kind, with all due respect to Lord Justice Knight. One of the notices that filed by the joint FESCO defendants in response to the application cites the Ingenious Games case in this regard too, to say that when it is said, well, each ground of appeal must be grappled with, and a failure to grapple with is a relevant problem, that means and must mean completely failing to understand a clearly articulated point. That, in our submission, overstates it, and you see that in the Mariana decision, which is why I jumped ahead to say it. But I accept it's got to be a decision that matters, and the point has to not have been identified and not grappled. Can I then come to the nature of the inquiry, which was the third law point? It comes really from the Wingfield decision, which is quoted in Mariana. So we could see it in Wingfield, but I'll stick to Mariana because it's quoted. And paragraph 60, we see the 5 requirements set out. And then turning over the page, there are further references to Wingfield in the paragraphs on page 101, including paragraph 63, quoting from paragraph 66 of Wingfield, to say, the application for reconsideration of the refusal of permission involves a 2-stage process. First, the court should ask whether the Lord or Lady Justice of Appeal, who refused permission to appeal, grappled with the issues raised by the application for permission, or whether they wholly failed to do so. Secondly, if the Lord or Lady Justice of Appeal did grapple with the issues when refusing permission to appeal, the court should ask whether in doing so a mistake was made that was so exceptional, such as failing wholly to understand a point that was clearly articulated. That is where that point bites, which corrupted the whole process, and but for that error, there would have been a different result. So what that so articulated suggests is there are 2 gateways, as it were, if it's not confusing to use that word in a jurisdiction case. But the one is, did the Lord Justice of Appeal fail to grapple with the material point? The other is, what did they grapple but make an exceptional mistake, such that Had they not done so, there would probably have been a different result. Now, so articulated in that paragraph on its own, it would suggest, but this is not my submission to be clear, it would suggest that the probability of different result applies to the second gateway and not the first. But to be clear, I accept it applies to both.
Yeah.
I accept it applies to both. That takes me, Lords, to the injustice requirement. And again, going back to page 100, you see it's stated in two ways. Paragraph 2 of the quote in paragraph 60 from Wingfield. There must be a powerful probability.
So it's not enough to, sorry, just looking at that passage, it's not enough to say where the judge did grapple with something, that the judge's decision was wrong. In other words, that you come along and say, well, we think that there was a better decision that should have been made. It was that the mistake was so exceptional, such as wholly failing to understand a point.
Well, that of course would be an example, but yes, it was exceptional.
And that it must have corrupted the whole process, and would, but for the error, would have probably led to a different result.
Yeah.
So it's got to be, if you like, an absolutely fundamental error.
So
It's not an error in the sense of saying, well, we now say,
we now think differently.
but he should have come to a different conclusion. It's not an error in that sense. It's an error which is so basic, and it goes back to the process aspect of this, that it corrupted, as they say, it corrupted the whole process.
Yes, so some of the quotes are a little slippery only in the sense that there are they throw up examples of the kinds of things which might activate this jurisdiction. But of course they're thrown up as examples, not as definitions. And it's important to be wary of that. But in answer to your Lordship's question, I completely accept. I need to show first one of two things. Either a failure to grapple with a point, and I accept for that purpose, it's a material point, however one wants to put it. A failure to grapple with a point, or an exceptional error in the consideration of the point, so one of those two things. And in both cases, that upon a proper analysis, it can be said that it is probable that but for that error, but for either the failure to grapple or but for the error in the course of grappling, there would have been a different result. So I don't shrink from that burden. And as to the different result point, going back the previous page to paragraph 60 of Mariana, quoting from Wingfield and what are sometimes referred to as the Wingfield principles, you get them in subparagraphs 1 to 5. And the way that they are there set out, you will see that subparagraph 2 is that there must be a powerful probability that a significant injustice has already occurred and that reconsideration is the only remedy. And paragraph 5, there must be a powerful probability that the decision in question would have been different if the integrity of the earlier proceedings had not been critically undermined. And I accept they are stated as two different points, but to some extent, I don't mean completely, but to some extent, they're a gloss upon each other. You do have to show the probability that there would have been a different result, and I accept that. In our submission, however, and this is an important point, it is not necessary for this application for us to persuade your Lordships that if permission had been given, the appeal would have probably succeeded. When reopening an appeal, that may well be the bar. But when reopening a decision on permission to appeal, the target is the question of permission. Now, I appreciate your Lordships may say the exceptional nature of the rule and the couching of it in language of injustice does have an eye to some extent on the ultimate result. But it could never be right that in this application we would have to argue the whole appeal. We then really would be here for at some length of time. So I would seek to persuade you that that is not a target we have to hit. That takes me to the fifth point, Lord's alternative remedy. And it's a point made in the joint FESCO responding notice. Your Lordships might just pick it up if you would. So that's in your miscellaneous bundle, tab 14, page 56.
Sorry, hold on. Miscellaneous.
Sorry, I'm just looking at something in the Mariana case. Sorry.
I'm sorry, shall I go back to it?
Yes, I mean, I think there's some support for your submission, the submission you've just made about what you have to show is there's a powerful probability that the permission test would have been reached rather than the appeal would have been met in paragraph 105, level 3 of Mariana, where in their conclusions, the level 3, the way that the Court of Appeal puts it, is in our view, if the appellate judge had grappled with the grounds in question, there was a powerful probability that the outcome would have been different and that he would have granted
Yes.
PGA. So they
Yes,
seem to be
indeed.
looking at that target rather
Exactly.
than
And what
the
you
substantive appeal, as it were.
indeed, and what your Lordship will have seen in Mariana is after the law is dealt with, the court worked through the various grounds which it was said had not been grappled with, leading up to the conclusion that you see in paragraph 102 on the previous page, concluding that the appellate judge had failed fundamentally to grapple with the points that are there listed, A, B, and C. And that then flows through, as your Lordship says, to the conclusions in paragraphs 105 and 106.
Sorry, what was the next point?
So the next point was I wanted to deal with alternative remedy, and I wanted to ask your Lordships to open up the joint FESCO responding notice in miscellaneous bundle tab 14, page 56.
Sorry, can you tell me again?
Yes, miscellaneous bundle,
Yes.
tab 14,
Yes.
page 56. It starts a little earlier, but
Yeah,
it's
56.
page 56.
Thank you.
Paragraph 9. And that's really to identify the point that they make. They refer to 3 authorities which are in the big bundle on that page. I don't think we're going to need to go to them, but they are referred to say that an effective alternative remedy might constitute foreign proceedings, and it might constitute proceedings against third parties. And thirdly, they say it does not matter that those cases establish that it does not matter if those proceedings might be difficult. That's the point they're trying to make. The factual point behind their contention, which I'm going to come to in a moment, relates to the conclusion that Cyprus was the natural forum for purposes of this case. So the point that they wish to establish is that by way of alternative remedy, proceedings could be issued afresh in Cyprus. Just as to the 3 cases that they cite, I really don't want to drag through them, but just to tell your Lordship what they were. Mania and Secretary of State was an application for judicial review of an extradition of someone who'd been convicted of some serious offences in Romania to serve a foreign jail sentence in Romania. It had a complicated history of previous applications. And in the application that came before the court, there was an argument that the criminal convictions, or at least the sentences, were too harsh in the light of certain EU law points. And the conclusion of the court was that the EU law points could be raised in Romania, and so there was an alternative remedy. That's the point it makes, paragraphs 27 to 31. If your lordships need it, it's Main Authorities Bundle, Volume 9, tab 69, page 2764. The second case they referred to...
Was that alternative remedy in the context of judicial review, or was it in the context of this rule, 5230? Because alternative remedy is a defence to a judicial review.
It was technically both. The application, I should have said a little more, I'm sorry. The application was an application for judicial review of the decision to extradite. But there had been a complicated history of previous attempts to reopen the extradition process, which it's unnecessary to go into. Having dismissed the judicial review, the court also went on to consider, although it is not what the nature of the application was, whether it could have been, I think that the person may have been at some points a representing person, I don't know, but in any event, to consider whether it could be understood as an application to reopen an earlier appeal under CPR 5230. And in that context, concluded that the EU law points could be raised in Romania. And if your lordships need to see it, as I say, it's volume 9, tab 69, 2764, paragraphs 27 to 30. The second decision they refer to is Ceredigion Recycling versus Clifford Pope. And that was an application to reopen permission to appeal against a judgment upholding claims for breach of fiduciary duty against a director. Again, there'd been Lady Justice Andrews had been sufficiently persuaded on the papers to refer it to an oral hearing, persuaded that the relevant Lord Justice considering permission, Lord Justice Popperwell, had not grappled with a key issue on appeal. So there was then, as today, an oral hearing on both the application and permission, and concerns lots of points which don't matter for purposes today to challenge the nature of the limitations in this jurisdiction. But right at the end, Lord Justice Flo added an obiter comment that there might in fact be an alternative remedy because the would-be appellant could sue his previous professional advisors who advised him at the time he did the things which were found to be a breach of fiduciary duty, and that might be an alternative remedy for these purposes. But Lord Justice Flo did not in fact decide that point. So it's put up as an illustration of the possibility that in the right circumstances, an alternative remedy might constitute suing somebody else. And the third case...
Where is that in the bundle?
I'm sorry, that's volume 9, tab 65. And the relevant part is on page of the bundle, 2624, paragraphs 49 to 51. The third case that they refer to was a very late application to reopen an appeal on this occasion, not permission, but the appeal itself, by a defendant who'd been found liable on a bill of exchange. That's First Discount and Guinness. When I say very late, it was 10 years after the event. And the first appeal had been dismissed notwithstanding new evidence, and the application then sought to rely on yet further new evidence. And that new evidence was to say that key parties had made a fraudulent misrepresentation which led the defendant to sign the bill of exchange. And the main reason, it wasn't the only reason, but the main reason that it failed was the conclusion that actually he had two alternative remedies, and they were to sue the deceitful party that induced him to sign the bill first, or second, because, of course, all of that concerned the evidence that had been given in the case itself, to bring an application to have the judgment set aside on the grounds that he was procured by fraud under the Highlands and RBS case. And the defendant complained about, well, he might then face limitation issues, to which the suggested answer was, well, if there are limitation issues 10 years later, that's your own fault. And that is Main Authorities Bundle Volume 8, tab 55, bundle page 2381, paragraph 12. And that's what the respondents rely on to say, well, if it's difficult and if by now limitation has become a problem, well, that's your own fault. Now, those cases are what they are, and I take them to you because the respondent cited them. But they each turn on very particular facts and their own facts. They don't really help. The question is, why do they assist in this case? And so turning to the substance of the point, so I'm now departing the law and dealing with actually what the objection is as to alternative remedy. The substance of the point is that at least as to the appeal on forum convenience, proceedings could be instituted subject to all defences in Cyprus, and therefore it is said there is an alternative remedy which is viable, which is to sue in Cyprus. And we suggest that can't be right, Lords, and I want to explain why. The first point, leaving aside expiry of time and everything else, is that none of the TPG defendants, that's defendants 1 to 7, Rosatom or DP World, agreed to submit to Cyprus.
So give me those again. So
None of TPG, that's Ds 1 to 7, Rosatom, which is D17, or DP World, which is D18, agreed in the course of proceedings or before to submit to Cyprus. Indeed, as to those, Rosatom positively said the only place for this case was Russia and it would not brook anything else. And as to the TPG defendants, having elected not to challenge jurisdiction, the point was raised in the hearing and it's recorded in the judgment, and they confirmed their position that they would not challenge the jurisdiction.
now that TPG are involved in the FESCO
That's correct.
conspiracy.
Yes.
DP World are involved in the
FESCO.
in FESCO.
All of those are involved in FESCO.
They're all involved in FESCO. Right?
All of those are FESCO. Now, over and above that, given the nature of the decision by His Lordship Mr. Justice Bright, it is also true that in proceedings in regard to at least the FESCO conspiracy, but perhaps also the NCSP conspiracy, there would, in fresh proceedings in Cyprus, necessarily be potential issue estoppel question. And while it is said by the respondents that the claimants might argue that those issues don't arise, there plainly would be issue estoppel issues. And none of the three cases that they refer to identify as an alternative remedy the availability of another forum in which a case might be launched but would be subject to issue estoppel or res judicata or Henderson and Henderson abuse of process. So it really isn't the same position at all. And the third reason why we
So can I understand that? So you say that if your clients were to bring proceedings in Cyprus where the evidence suggests that the approach on jurisdiction is much the same as in this jurisdiction.
Yes, one perhaps shouldn't overstate that, but to
Right,
some
there are
degree,
similarities.
yes, that there are
The-
similarities, yes.
So one of the questions might be, say, whether there's a serious issue to be tried.
Well, the question would be, the way that I'm putting it, do the findings as to strikeout or summary judgment, which is a wrinkle I'm going to have to come to, in regard to the defendants 1 to 7 and defendant 21, Mr. Garber, in the judgment, constitute final decisions for purposes of issue estoppel or res judicata. And there would be complex debates about that. I'm not suggesting we wouldn't try to argue the opposite of course we would. But
And those might be taken in the courts of Cyprus. Is that the point?
well, it's a racing certainty that they would be taken along with every other point. the defendants, even those who've submitted, making clear that they, when saying that they would submit to Cyprus, expressly reserve the right to take each and every point already argued and any other. And I say that's the sort of difficulty that is not what was contemplated in the three cases to which they referred, which said, well, it doesn't matter if those cases might be different. That's not a real alternative remedy. And the third point I wanted to make really is in our submission also fundamental, which is that the application for permission to appeal included an application for permission to appeal on the finding that Cyprus was the right jurisdiction and rejecting England as the appropriate forum. And so baked into the proposition that the respondents put up is the idea that, well, even though, for argument's sake, and I appreciate this is for argument's sake, even though for argument's sake you might have good grounds for saying that you should have been given permission to appeal on the appropriateness of the English rules, nevertheless you should be denied reopening because you can just live with the other jurisdiction. And again, we say there is nothing in the authorities that say that kind of position is an alternative remedy such as to mean that we do not pass through the filter created by paragraph C of the rule. There is then a further substantive point that relates to this that I need to deal with, which is raised by a different defendant, which is now on the NCSP side of things. In the Transcript respondent's notice, which is in that same bundle at tab 19, page 95, paragraph 30, there is a reference.
Okay.
Miscellaneous bundle, tab 19, page 95,
Yeah.
paragraph 30 and following. It goes on for a few paragraphs. And you'll see that they refer to something there called the 336 claim. They've just given it that as a shorthand for its case number. But I'll also call it the 336 claim. What is that? It is a protective claim form issued out of this court, but not served, which seeks to protect a claim arising from some further evidence which emerged and amendments which were refused. Now, I apprehend your lordship's preparation may not have got quite so far as to understand what all of that's about, and so I'll deal with it in a little bit of detail, but please hurry me up if that is not the position.
Is this the idea that some of the defendants received a secret commission, effectively?
That is right. So you would have seen in the judgment, the Lord, at paragraphs 285 to 290, reference to the fact that evidence emerged after the claim had been issued of an arrangement between Ms. Mamadzad and Mr. Kuzakov and a company called Epitikia. And what that evidence related to was their attempt to secure a very, very substantial commission if the sale of the relevant asset, Omirico, went through at the 750 million undervalue, we say significant undervalue. And some of the facts are referred to in the judgment. There are some things which are not dealt with in the judgment, and I should go on to deal with that. That is, the claimants applied to amend, to introduce allegations about that for purposes of the NCSP conspiracy. And that would include, I use the word joining now in a loose sense because he was already a party, but that would include joining Mr. Kuskov to the NCSP conspiracy. He was already a defendant identified as party to the FESCO conspiracy, but he would now also be identified in the NCSP side of things. And there was an application to amend and a hearing, and His Lordship Justice Bright refused permission to amend on the basis that, and this is recorded in the judgment, that even if it did show wrongful conduct on their part, that commission arrangement, it had no connection to the conspiracy, and there was not a basis to say Transneft was aware of it, and it was therefore irrelevant. So its judgments, it's 285 to 290 million. which are at Core Bundle, tab 5, page 201. But a significant point, which is then, I think, only half dealt with, is the claimant sought to appeal that refusal of permission to amend and obtained permission for that appeal from Lord Justice Papua. If your lordships need to see his decision granting permission to appeal, it is at Supplementary Bundle, tab 29, page 203. I should, in fact, perhaps take your lordship to it, because there is a point about it that's important. So, Supplementary Bundle, if you wouldn't mind opening that. Tab 29. And you'll see decision, permission to appeal on ground 1 granted, permission to page 203, permission to appeal on 2 other grounds refused. Ground 1. It is arguable the judge was in error in failing to treat the allegations in the disallowed amendments as having a real prospect of establishing conduct, evidencing and pursuant to the conspiracy pleaded. And then goes on to deal with that in some detail, with saying it is arguable that the judge was wrong to consider the things in numbered paragraphs 1 to 5. And the substance of that is that permission was allowed because it was arguable that this could be tied into the conspiracy alleged against Transcript. That's the critical thing. So permission was given to introduce effectively more allegations against Transcript, if you like, but also against Ms. Mamadzar and Mr. Skuzkov. And in the interim, in order to protect their position, because permission had been refused, a protective claim form was issued. When it came to His Lordship Mr. Justice Bright's judgment on the merits, he effectively, and I'll come back to this when we get there, he effectively continued to treat the epitikia allegations as only going as far as he had found that they did in refusing permission to amend, and therefore disregarded the fact that there was a pending permission to appeal, identifying the fact that it was arguable that they went wider than that. And that's quite a fundamental problem in his decision, and in turn then affecting this application. But as to the alternative remedy question, Transnet says, we'll run your protective claim.
What's happened to that appeal?
That appeal was stayed pending the application for permission to appeal underlying this application, and remains stayed pending this application. And I can find the references to that if you need it, but the answer is it's stayed pending all of this. Transnet suggests that claim provides an alternative remedy against Transnet, Ms. Mamadzar and Mr. Kuzakov. And we just say, well, Transnet would have to be served, would plainly rerun all the same arguments it's run in this case, no doubt relying on issue estoppel and the like. It's true we would argue the contrary, but nevertheless that's what it will do. And really to test the argument as an alternative remedy, the lordships might assume, just for the sake of argument, as a thought experiment, that the appeal against the refusal of the amendment would succeed on the merits if it went forward. And second, that his lordship...
Sorry, can you just say that again?
So the thought experiment that I'm proposing is that if the amendment appeal proceeded, it would succeed. It's a thought experiment, it's not more than that. And secondly, assume that the findings made by His Lordship Mr. Justice Bright in Transnet's favour on all of serious issue to be tried, Russian law and permission to serve out, would all be overturned if this application was allowed and permission was given in this case. So assume all of that. then their argument is that even in those circumstances, the 336 claim, protective claim form, would nevertheless be an alternative remedy for purposes of the rule, such that, in fact, this application should be rejected. So in other words, you could not allow any of that to happen on those grounds. In effect,
But
requiring...
isn't the thought experiment the other way around? That what one, in order for it to be an alternative remedy, one has to assume that you can't go any further with this case. And then you're left with the 336. And then the question is that an alternative
Yes.
remedy?
I understand why Lordship puts it that way. Can I explain why I put it the other
It's
way?
not even a thought experiment, it's just the question
Yes, exactly.
raised by the rule.
Yes. Of course, that's right. What am I about? I'm about asking what is it that that part of the rule imposes as a requirement when it refers to the availability of an alternative remedy in an open-ended way. And the thought experiment that I'm proposing, of course, there is a procedural, I'm going to call it procedural, whether you call it substantive or procedural doesn't matter. There is a requirement in the rule as to no alternative remedy. They say it is activated. What I'm seeking to highlight is if it is activated...
Sorry, I just want to understand. So, I'm sorry to interrupt you. Just to understand what this rule is about. The alternative remedy is not, is it, an alternative to a successful appeal? The alternative remedy is to an order for reopening under 5230.
Well, that happens to be true in this case, but obviously 5230 as a jurisdiction.
Isn't that the structure of...
No, that's correct. But obviously in some cases, under the application of the rule, it would be as to reopening an appeal. It just so happens that we are in a reopening a permission to appeal situation. So I don't attach any significance to that difference.
No, that's where we are at the moment.
That's quite right.
And so when we come to look at it in the context we're looking at, it's an alternative remedy to you reopening your application for permission to appeal.
It's an alternative remedy to, yes, if you like, to the permission to appeal application being reopened, yes.
Yes.
Instead of it being reopened, pursue your protective claim.
Yeah.
And what I was suggesting, and I concede that I'm making it too complicated, which is entirely, I take on the chin. But what I was suggesting by way of thinking about that was imagine, for the sake of argument, leaving that requirement aside, that the complaints about the decision of Lord Justice Mayles are good, that had he grappled with the relevant issues, he would have granted permission to appeal, and that appeal would ultimately have had a good prospect of success. So assume all of that. What they're saying is, well, you can instead pursue the same claim subject to our additional defences, including defences arising from this very decision, and that is an alternative remedy. And if you think about that, what that really means is that on their construction, there would always be an alternative remedy because, of course, in a simplistic sense, a claimant who fails can always claim again. They can always claim again. So don't stop them issuing a claim, unless they've been declared a vexatious litigant or something like that. They don't stop them issuing a claim. They would just meet defences of, but this case has already been decided. And that's what they say. That can't be a relevant alternative remedy for purposes of this case, and that's the submission. Lords, I want to get to the substance now. I am told that we have a transcriber who is remote, and I'm asked to allow for a transcriber break on that basis.
Okay, sure.
And so if your lordships, and now would be, just given where I am,
Because, yes,
the perfect time.
absolutely. What, 5 minutes?
As little or as long as your lordships like. Yes, 5 minutes is plenty.
Okay.
Right, if able.
I'm going to run up the passage, so you let me out there before they come back.
Okay, should we go outside for a
Yeah, stretch on me.
That we did the right time, just I was at the perfect time.
That's what I thought. Don't want to stop you mid-flow.
you ready to resume?
Yes.
Court rise if able.
Just checking, do we need to, is it stopping every hour? Is that what is sought?
It's
Or
normally one short break in the course of the morning.
and that's
one
what,
short break
is it
between-
one person there or is it two?
I have
so-
no idea, but it's
okay.
the absolutely usual practice.
But when
It's
you get
one break.
if you get a message through that they need another stop,
Then I
let
would-
us know.
Yes, indeed.
obviously.
Thank you very much. Well, at that point, I finally, as it were, want to turn to the heart of the matter. And what I wanted to do, as I said in the introduction, is first to just identify the core complaint, the core point,
Yes.
in respect of each conspiracy, and then develop it for each of the two conspiracies. And as always, one runs the risk of saying something summarily and then getting into detail later and being dragged across the boundary between those two. But nevertheless, it seemed to me to be valuable. As the application notice records, that's application bundle tab 1, page 2, the complaint is that the refusal decision does not grapple with a number of the essential arguments in the permission to appeal application.
Yes.
And the points are then summarised in the application skeleton in paragraph 4 from page 7, so that's application bundle tab 2, page 6, and then on to 7, paragraph 4, and seeks to capture what, paragraph 4 seeks to capture what it's about, and then goes on to deal with first FESCO and then NCSP. I'm actually going to take them in the other order, unless your lordship want me to do differently. Paragraph 4.2 of the application skeleton addresses the NCSP conspiracy claims and application for permission and its refusal. And the core complaint, if I can use those words, that is summarised there, is that Lord Justice Males addressed only the fair presentation issues, which were grounds 21 to 23 of appeal, or 20 to 23 of appeal, and indeed only did so in substance by deferring to his Lordship Mr. Justice Bright's assessment. And that in both of those ways failed substantively to grapple with both the fair presentation issues themselves and all of the connected issues as to the merits. And just to locate that in the decision of his Lordship Mr. Justice Males, that's application bundle tab 3, page 21. Sorry, turning to page 22.
Yes.
Paragraphs 10 through 12
Yes.
record in substance that it was sufficient to address fair presentation, and then in paragraph 11, or reason 11, if I can refer to it as that, the judge was entitled to find that there had been a serious failure, and this would have caused him to set aside his permission to serve out and to refuse any fresh application as the judge who had granted the permission in the first place. And with the benefit of the inter partes hearing, he was in the best possible position, and there was no flaw in this analysis, and amounts essentially to a matter of discretion. And we just say there that does not properly grapple with the problem for a number of reasons. The first is we submit that there really are some fundamental points in the fair presentation issues themselves, such that if Lord Justice Males had grappled with them, it is probable that he would have given permission. Secondly, we submit that properly analysed fair presentation, as distinct from re-grant, fair presentation itself is not an issue of discretion. And insofar as it was so characterised, it was wrongly so characterised. Because the question of what is material is an objective question. And Lord Justice Mayles should, in our submission, in our respectful submission, have grappled with the materiality of the non-disclosure. But it goes further than that, because baked within it was the abuse of process issue, and your Lordships would have noticed in paragraph 12, his conclusion on this issue was sufficient to dispose of the application as regards this conspiracy. Accordingly, the other grounds need not be addressed. Bracket, although I might have given permission on ground 11 if that could have been decisive. Ground 11 is the argument that it was an abuse of process for Transnet to raise issues relating to the closing of the relevant transaction, the Omirico transaction, and the approvals that were signed in the course of it, and indeed that it was an abuse of process for Transnet to raise questions of Russian law, although that's slightly aside from the present point. And what Justice Mayles indicates that they might have been successful on their own if they could have been decisive, but they are fundamental to the assessment of the fair presentation case itself, or at least the first of them is.
Did it only affect Transnet, that point about abuse?
Yes, and the findings of failure of fair presentation all lie in the Transnet half of the case. In the
But not
NCSP.
only against Transnet, also against the other alleged conspirators in that regard.
There is a separate finding against, not against, in regards to the application for alternative service on Ms. Mamadzad, who was one of the other two conspirators. When I say there are three on that conspiracy, I'm including Mr. Kuzovkov, sought to be alleged to be such in the application for amendment, and the problem that I've already described, but not in the claim as originally formulated. I'm not sure if that's an answer to your question. So, fair presentation as a whole is confined to the CSP conspiracy.
Yeah, but only to all of the defendants to that conspiracy
There
claim.
are 3 points in the fair presentation analysis addressed by grounds 20, 21, 22.
Right, but sorry, just to jump ahead, because I know where you're going on this, but the first two grounds apply to all the defendants, not just to Transnet.
That's true, but they were arguments raised. So the corporate approvals point, if that's the one that your Lordship is referring to,
And the Russian state.
that's in a different
involvement.
category, and I'll come to it.
But that is one of the grounds of fair presentation.
True, my Lord. I'm struggling to be succinct, and that's someone.
Sorry, I'm interrupting you, but you explain.
As to the issue of abuse of process, that relates to, for present purposes, I'll leave Russian law aside, relates to the evidence as to the further process through which the transaction went after the contract was signed, which had not been dealt with in the particulars of claim, because it wasn't known about. In order ultimately to tee up an argument that any lack of authority was ratified. All of that was the subject of a contention as to abuse of process because of the principle arising from your Lordship's decision in Harrison and Mehta and others, which is that Transnet had already had a go at serious issue to be tried in the course of the injunction application, and had its chance to raise those points. And it was therefore an abuse of process to raise them again. Now, if that argument succeeded, none of that would be there in the case to constitute a failure of fair presentation. I, of course, appreciate.
But it would be against the other defendants.
No, because they were not the ones bringing that argument. They have a different argument. That was Ms. Mamadzad's argument. But in any event, certainly as to Russian law, she does have an independent contribution to that problem. So we do say the abuse of process could have been decisive to the fair presentation argument itself. And we say,
But can I just ask you about that? Fair presentation is about how you put things on the ex parte application, and you have to bring everything that's material before the court.
yes,
You can't, and I don't think you ever did, suggest that the facts which it would be necessary before the court and the evidence about those facts was, as it were, answered by your point of saying what you say now, well, there's this abuse of process point. Because that hadn't been decided at the ex parte stage. The point about fair presentation doesn't involve leaping ahead
of course.
to the conclusion which is ultimately
Of course, that's true.
made. It's about making sure that things are fairly presented to a judge at an ex parte stage.
Yeah.
And there may be a flaw, it seems to me, in the way you're putting it, which is to say, well, it wouldn't have made any difference anyway because of at the inter partes hearing, because we would have been able successfully to stop Transneft running these points at all. That seems to me to be...
It's a slightly intricate answer. So if I can try to answer a number of the points that your Lordship has made in the course of that. But I do understand the question. The first point is, where do the fair presentation arguments come from? Now, with some qualification, because the position on Russian state is very different, and I'm going to come to that. Normally, issues of fair presentation are raised by a respondent to say there was such a failure, we've identified, you failed to identify this. And therefore, the case should stop in its tracks, whatever the relevant permission was, in this case to serve out. It should be set aside. And then, of course, downstream, a question as to whether to re-grant or not. The authorities do not seem to me to show that the courts set about the question of fair presentation, as it were, unstructured by the points that the defendants raise. Although, as I will show you, that's exactly what happened on the Russian state issue.
Do you mean that the defendants raise at the inter partes hearing, or that they might be expected to raise?
No. In other words, it's an inquiry that is structured and initiated by the fact that the defendants subsequently raise the points and contend for the setting aside of the underlying permission. And the court then decides that it's either persuaded that that was not. If it is, it sets aside. And then there, of course, is an issue as to re-grant, but leave that aside. It's not, as it were, a roving, freestanding inquiry without that kind of presentation of an issue to the court. So if it was an abusive process, the necessary consequence of that assumption, assume that it's so, is that they shouldn't have been able to raise it at all. And if they hadn't been able to raise it, it would never have come into consideration. Now, your Lordship is, of course, right that the duty of fair presentation is a duty owed to the court at the without notice stage. And in the example that I give, would then still have been a failing in that presentation, but it would never arise for decision in the case. That's the submission that I made.
But the authorities show, I think, that the question isn't whether it would actually have made a difference.
No, that's also true. That's also true, and I accept that too. But nevertheless, that doesn't change that perspective.
And you don't know at the ex parte stage what's going to be decided on these points. And so the idea is you have to bring... It's in the concept of it being a fair presentation.
That's, of course, is right.
And here, in fact, the judge has decided the as it turns out, has decided the abuse of process point against you.
Yeah, that's correct.
Now, you say, oh, well, we might be able to overturn that on appeal, but looking at the process before the judge and whether it was fair or not, he says, well, I know you disagree with this. All of this material was important because it went to the process by which the contract was completed in September. And that, he says, was a very important part of the inquiry, and it wasn't put forward by your side. Now,
Yes.
I don't understand at the moment how you can then turn around and say later, because he's saying that should have been brought in at the ex parte phase. You can say, well, it might have been open to us to argue that this stuff shouldn't be looked at all because Transneft hadn't taken the point on an earlier hearing.
Well, so
That would undermine the idea of a fair presentation.
and the submission that I'm making accepts entirely the starting point that the duty of fair presentation is a duty owed to the court, because it is. And it is a duty to deal with material matters. Now, of course, we've also got some points. We've got some other points, but it is a duty as to material facts, which might have an influence on the assessment that the court at the without notice stage is having to undertake. So I accept that. I accept that too. But having accepted both of those things, the ordinary situation in which decisions are made at the inter partes stage to find that the without notice permission should be set aside with whatever consequences that has, is where a party, a defendant, has raised the point for consideration and put the material and the issues before the court, that it is said should have been put before the court before. And in that sense, you have a live debate in which an issue is being presented. An issue of failure of presentation is presented by a defendant. If no defendant presents an issue of fair presentation, the ordinary result is fair presentation simply doesn't fall to be decided at all because nobody's contending.
But they did contend it here.
That is true, but they did so by means of an abusive process.
I thought your point was, and I may well have got it wrong, probably have, is that there's an apparent inconsistency in 10, 11 and 12 when Lord Justice Mayles referred to the challenge to the abusive process decision as being, as he might have given permission.
Yes.
So you're saying if that had substantive merit, that itself would undermine the decision in respect to fair presentation, because if the abusive process argument on appeal succeeded, then fair presentation wouldn't arise at all. I thought that's what you were saying.
That is exactly
so you were
what I'm
dealing with the internal, you're suggesting, is it internal inconsistency or internal something or other between 10, within 10, 11 and 12? Is that not, you're saying something else?
No, I don't think that I am saying something else.
Right.
Whether exactly the labels one attaches to it, whether it's all about inconsistency or whether it results in a failure to grapple, or how one may frame that particular problem, one can look at. So I don't want to be so
is it failure to grapple with the prospective merits of the abusive process argument when deciding that the challenge to the fair presentation decision didn't have merit?
Quite. So can I put it back to your lordship just to see that I'm putting it in my own terms? But I think I accept what your lordship has just put, which is that Justice Mayles indicated that if he thought it would be decisive, he might have granted permission on ground 11, which is the abusive process ground. Again, I take that to mean that he considered that it was a proper subject for permission. It was arguable that there was an abusive process. My next point is that if there was an abusive process such that the issue of the corporate approvals should not have been raised before the court at all, then it would not have arisen for debate as a fair presentation issue, and Transneft, which is the party that contended for the failure of fair presentation, would not have been able so to contend.
But that's
And
a
that
very odd
means-
thought experiment, if I may say so, because that's assuming that you've got a ruling in your favour that it is an abusive process. That's not how the process works. Fair presentation is about fair procedure. At the point where the ex parte application is made, you don't know whether you're going to win on your abuse argument or not. Indeed, it was hotly contested and you lost on it, as it turns out.
Yeah.
So your argument assumes not only that you have permission to appeal, but that you're actually assuming it is an abusive process.
Well-
and you don't know that at the ex parte stage.
That's the point that I accepted in response to your lordship's question,
Yeah.
which was that your duty at the without notice stage or the ex parte stage is a duty to the court. And in the academic sense, you also may criticize me for that word, but I'm using it for a purpose. In the academic sense, there will still have been a failure of fair presentation of that issue. It'll just never arise for decision in the case. And my answer to that one is, our courts make decisions setting aside previous permissions upon the basis of properly supported and argued contentions raised by parties as to the failure of fair presentation, not by way of roving inquiry.
Yeah.
Now, if I'm
And
wrong
then
on that,
but at the next stage,
but if I'm wrong on that,
yeah.
of course I accept that
No,
I'm wrong
I agree,
entirely.
but that's not the way we do things. But so points have to be raised. But the point clearly could properly be raised here because it was one point of view, and this happens very often on in these kind of interlocutory proceedings where, as it turns out, the judges very often have to decide, for example, the merits of freezing injunction applications, but they also decide the fair presentation point. They do it in the same way here by going through all of the various arguments. But the abusive process argument wasn't decided at the point when Transneft said, well, this was a fair presentation failure. And so the judge properly did deal with it. It was before the court.
Let me see if I can put it this way, and it's either a good answer or it isn't, of course.
Yeah.
And I'll move on to my downstream
Yeah.
answers, which I also. I appreciate we're at the stage of seeking to reopen a permission application, but I want to roll it forward on the assumption that permission was given on everything, and we were arguing the final appeal, because I think that's really the way to test this. So my proposition is that if all the grounds were in, and we were in the final appeal, and the court worked its way through the grounds of whatever order it wants, but obviously considered all of them. And so far as this point is concerned, the abusive process point, decided or reached the conclusion that there was an abusive process, the point should never have been raised. The question then would be, before that appellate court, notwithstanding that, can Transneft nevertheless contend for a failure of fair presentation? And that's mad, with respect.
I'm not sure it is. Fair presentation is about how you present cases to the court.
So what that means is
And it's clear from the authorities that there's a penal element.
Well, of course. And I've accepted all of that.
You can't. Your argument is to leap ahead to the conclusion, say, well, that's where we've ended up. Therefore, we never had to present the same thing in the first place. Or you would say, well, maybe we did, but no one can complain about it. But then, how does that fit in with the idea that this is about the proper administration of justice?
That's why I accepted all of those points. But I nevertheless
You accept them, but then you make them.
No, I accept that those are the duties. But what I say is, nevertheless, the court would not, in those circumstances, entertain the party who has been found to have abused the process, nevertheless arguing the very thing, the very material, that is an abusive process, is a failure of fair presentation. But I appreciate there is a sort of catch-22 type problem here about what one assumes at what stage.
Yeah.
I want to continue that point in regard to Russian state, but I just want to finish the other points in regard to corporate approvals first, if I may.
Yes, sir.
Because it arises in a completely different way in the Russian state context, and is helpful. In the corporate approvals context, the grounds go on to say, in fact, what the judgment doesn't deal with is that the necessity for this approval process was not a condition precedent to the contract being binding on the relevant party, which in this case is Port Petrovsk, the 10th claimant, because it had an express clause. The contract's unfortunately not in the bundle, but had an express clause 4.3 showing that Fenty, the counterparty, could hold Port Petrovsk to the contract, even if the approval resolutions were not produced.
Sorry, say that again.
Um,
So which company?
If we go to our organogram, it is where these things are useful. So your lordships are using, this one doesn't matter, so it can be annexed 2 to the judgment.
Yeah.
The two shareholders in the company that is third up from the bottom, Americo Limited. The two shareholders were Fenty Development Limited, as you see on there, and then following the dotted line up the left, Port Petrovsk Limited, which is the 10th claimant. The relevant transaction about which this whole conspiracy allegation is concerned, or with which it's concerned, is a sale and purchase agreement concluded between those two parties for the sale of Port Petrovsk's shares in Americo to Fenty. So we should with the The point made in the Commission to Appeal skeleton, amongst others, and I'll find the reference for you, is that under clause 4.3 of that agreement, even if the corporate approvals that were the subject of this entire analysis were not produced by the Port Petrovsk side, nevertheless, Fenty could hold Port Petrovsk to the sale. Now, I appreciate that doesn't get rid of entirely the fair presentation point, but its consequence, if right, is that the very substantial focus that followed on the approvals process was at least somewhat displaced or misplaced. Because even if those approvals didn't come, that would be the result. This is a point made in the PTA skeleton for your lordship's reference from page 92 of the bundle. That's the core bundle, and it's paragraph 175 and following.
And was that a point that was taken before the judge?
Well, the honest answer is I don't think I know, but there's not been any suggestion it wasn't, if I can put it that way. And I'll have to take instruction on that. Obviously, the argument about the approval process was pursued at some length. Whether there was reference to clause 4.3 or not, I don't know. But I will clarify that. Secondly, so that's the approval point. In other words, there is good reason to say the approvals didn't matter. The third point is that the approval on the Port Petrovsk side is then given, and the judgment deals with this part of it. Does your lordship still have Annexure 2 in front of you?
Yeah.
Yeah. So the next company above Port Petrovsk is Chevron Investments Limited, BVI company, after which it splits between the two brothers, each with an intermediate holding company, and then up to the two brothers, as you wish to see. And the critical approval, so far as the analysis and the judgment is concerned, is at the stage of closing, or the end of September, signed by Mr. Karmakov as the sole director of Chevron Investments Limited. But he is also the party who had signed the SPA itself for Port Petrovsk. And the allegation is that the sale was at a very substantial undervalue, such that his doing so was not only unauthorized, but a breach of duty. Now, I appreciate the other grounds that attach to it. It being a breach of duty, it would remain a breach of his duty to Chevron to sign the approval. And in those circumstances, the submission is that could not constitute 100% shareholder approval or ratification of the unauthorized transaction on the duomatic principle.
Now, he's not said to be a conspirator, is he?
He is said to have, he's not said to be a conspirator, he is said to have breached his fiduciary duty. And there's a separate grounds 12 and 13, then also concern this. So
what was he doing giving approval if he wasn't a conspirator? If he wasn't trying to damage the UBO?
The short answer is attempts were made to get explanations and evidence from him, and he closed up, so nobody knows.
But what's
so
your
one of the
case?
points
I mean, how does that work if he's not a conspirator? And he's
I'm
obviously doing it as far as he's concerned. Sorry, I say obviously, but it's a reasonable inference that he thinks he's got the UBO's consent to that, in looking at the structure.
The court accepted. Perhaps I should go to this. That we came to the question of whether there was a serious issue to be tried on this conspiracy relating to the conclusion of this agreement at a significant undervalue. The court followed the injunction decision of His Lordship Mr. Justice Butcher in taking the analysis to the point that said the decision to the signature of the SPA itself by Mr. Karmakov at a significant undervalue, given what everything else that was happening, and given the threat which Transneft had made, that there was a viable, arguable case for conspiracy to that point. That's why a serious issue to be tried was upheld by His Lordship Mr. Justice Butcher, and His Lordship Mr. Justice Bright, just find 561, just find His Lordship Mr. Justice Bright accepts the analysis to that point, and then moves on to say, but Transneft have in reply, and despite having had a previous opportunity to do this, now raised all of this evidence as to the corporate approval process. And they said the operative approval is that the very same Mr. Karmakov signed the approval resolution later in September for Chevron. Is your lordship with me? Just as to what the facts are.
Yeah, I mean, I think you said earlier that he was the sole director of Chevron.
I did say that.
Isn't the judge's finding that Mr. Muslim Gadseyev was also a director of Chevron at paragraph 222?
I must see that I have not confused myself in the process of it. That won't matter for the purposes of the argument. So can I park that and clarify later? For Chevron to have acted as under the geometric principle, approving this transaction, it either needed Mr. Karmakov or it needed both of them. But in any event, it needed Mr. Karmakov. That's why I focus on Mr. Karmakov. The court had already found, or His Lordship Mr. Justice Butcher had already found, and His Lordship Mr. Justice Bright was inclined to follow that, the signature of the SPA itself by Mr. Karmakov was without Mr. Magomedov's authority and established an arguable case for conspiracy. It can't be better, which is my present point, if the same Mr. Karmakov takes a subsequent step, providing the same approval to the transaction at a higher level, because the analysis must be identical at both levels. And that's my point. And therefore, that there is a good answer to the approvals analysis, and to bring to bear the only evidence as to Mr. Magomedov's position, which is he never authorized this transaction at all, dealing with the corporate structure. And Geomatic, therefore, did not create a solution. So, to recap, I make the point about whether the fair presentation issue would arise at all. Separately, we have 2 points to say that the approvals point was bad. One, relating to Mr. Karmakov's approval is critical to the process and cannot be better than his approval of the SPA itself, which was already found by His Lordship Mr. Justice Butcher to create a serious issue to be tried, and the judge was inclined to go along with it before moving on to the approvals question. I'm sorry that I've lost the reference, and I will come back to it. I wanted to turn to Russian state, which is the second ground of failure of fair presentation. But I see your Lordship paging through the judgment, and it's my fault that I haven't got the reference immediately to hand. I'm not sure whether your Lordship would like me to find it, or whether I can deal with Russian state and then come back to it.
Yeah.
So far as Russian state is concerned, there is a second fundamental problem. It is that problem now with an added element, which is that nobody contended that there had been a failure of fair presentation on what His Lordship Mr. Justice Bright calls the Russian state issue. It is an issue that was debated because of its effect on other things, including, in particular, the linkage question between these two conspiracies. That's what it's fundamental to. The question is whether it creates a position such that there are two conspiracies, both of which are being driven by the Russian state, and having them in the same case therefore makes sense. And so that would be one of the reasons, it's not the only gateway, but it would be one of the reasons to bring the claim for the CSP conspiracy to join the claim for the FESCO conspiracy in England. It's in that context that it was debated. And there was a change of position at the time of the first inter partes hearing. Your Lordships may appreciate there were two inter partes hearings because, for reasons of case management, the court dealt with the FESCO side of things in the first hearing and the NCSP side of things in the subsequent hearing. So that's how the Russian state question arose.
And when did it rise?
It arose of course, it affects various things, but its direct relevance was to the gateway question.
Yeah, sorry, it's just on the timing. You just told us, I think, but I didn't get a note.
Oh, I'm sorry. It arose at the first of the two hearings. So at the hearing into the Fesco conspiracy,
Yeah,
when gateways were considered, there was a change of position. And other issues were considered. It then affects gateways. When the issues were considered, there was a change of position on the claimant side. And whereas it had been alleged in the particulars of claim that the Russian state, the particulars could be so understood to allege that the Russian state was party to the conspiracy, it was made clear by the claimant that for purposes of the Fesco conspiracy, the first one, that was in fact the second one, the Fesco conspiracy, not the NCSP conspiracy, for purposes of the Fesco conspiracy, the claimants were going to run a case that did not involve seeking to establish that the Russian state was a conspirator. I'll take you to the letter to see exactly how it is set out, but I want to make the point of substance first. That, in turn, caused His Lordship, Mr. Justice Bright, some concern. That concern arises most particularly, I don't mean exclusively, but most particularly, because when at the permission to serve out stage, consideration was being given to whether to permit service out also in regard to the CSP conspiracy and in regard to the Fesco conspiracy, the issue arose of why these two partially separate claims were being joined into one proceeding. And that is, of course, directly relevant to debates about necessary and proper parties where they arise. So what happened in the September hearing is all of this arose in the course of the hearing. The judge expressed some concern about it. And at the end of the hearing, or shortly after the end of the hearing, a letter was written, which then expressed the position. And I do want to show you that letter. I've so far departed my notes, but I no longer have the notes in front of me, and I do apologise for that. But
it is also obviously referred to. Are you referring to it in the judgment or separately?
no, I want to show you the letter.
Okay.
Just find the letter in the supplementary bundle.
Which bundle is it in the
It
supplementary?
will be in the supplementary bundle. But the point is, that gave rise to a concern, understandable concern by His Lordship, Mr. Justice Clark. But the point that I'm driving to is it did not lead Transcript to contend that there had been a failure of fair presentation.
is it at tab 40?
I think it's tab 40, yes.
So is it the 23rd of September letter?
That'll be it. Yes, thank you. But I do apologise for that. As I say, I've departed my legs.
You say, sorry, you were just halfway through a sentence. You were saying it did not lead
to Transcript
Transneft
or Ms. Mahmadzad contending that there had been a failure of fair presentation in the sense that the Russian state link had been misrepresented to His Lordship, Mr. Justice Bright, at the without notice stage. And just to locate this in time, paragraph 1 of the letter refers to an email from the judge's clerk sent on the Friday evening, that being, I think, the end of the Fesco part of the inter partes hearing. And this letter is then sent on the Monday. And you will see that what it explains in paragraph 3 and paragraph 4 is that in the light of the concerns expressed at the hearing, in relation to deciding to present the applications now, in deciding to present the applications on a narrower basis than the case might be put generally. The claimants now confirm in relation to the FESCO conspiracy that they do not run the wider case, in particular, no case that the FESCO conspiracy involves as conspirators persons acting or purporting to act on behalf of the Russian state. 2, that the Russian prosecutors were party to the FESCO conspiracy. 3, that the parties to the FESCO conspiracy include members of the Russian state. In other words, the confirmations given orally by Mr. Doherty apply generally. Paragraph 4, but for the avoidance of doubt, the claimant's case that the conspiracies nevertheless form part of a campaign waged against Mr. Magomedov by and on behalf of the Russian state, as pleaded at, and it cites 2 paragraphs, the particulars of claim. In other words, that remains. So what is it standing back that happened? In the light of other issues and debates, a decision was taken at the inter partes hearing to narrow the FESCO conspiracy case so as not specifically to allege conspiracy, but against the Russian state, but to make clear that the conspiracy itself nevertheless formed part of the Russian state's broader campaign. Whereas in the case of the CSP conspiracy, it is said that the Russian state was party to.
How is it part of the campaign and not a conspiracy?
Well, the question in the end is, of course, to look at it from the claimant's perspective, the question is, are we advancing a case, one of the elements of which is, which we will have to prove, that the Russian state was a conspirator? And there are obvious downstream consequences in regard to debates about active state and whether the exceptions to active state principles apply, and so on. And so the strategic decision is taken. We don't have to do that. We do think it is so, but we don't have to do that. So we make clear that our case that we will run in this court is a case which will not involve that allegation. But we do nevertheless make clear that there was a wider Russian campaign going on, and this was part of it. Now, that then has whatever consequences it has, but it's a repositioning, a narrowing by the claimants at that hearing of the case in regard to the FESCO conspiracy. This being a year after the without notice hearing. It's a narrowing at that stage. Now, that happened. FESCO did not, Transcript did not, nor did anybody else, then raise the concern that that means that there was a failure of fair presentation at the without notice stage. And it was not, so far as I understand and can tell, ever put to the claimants by His Lordship Mr. Justice Bright that this gives me concerns about fair presentation, and I would invite submissions on that point. That never happened either. So the substance of the issue became part of the case. The substance of where was Russia and where wasn't Russia became part of the case. But it was never put up by anybody as a fair presentation point. And come the judgment, of course, His Lordship Mr. Justice Bright decides it was a fundamental, and he's very critical about it, failure of fair presentation. And that there are then 2 consequences from that. The first is that the answer to it was never heard. And in fact, the permission to appeal skeleton explains why what had been said at the permission stage, properly at the without notice hearing stage, properly understood, was entirely consistent with that presentation. But that debate was never had. And His Lordship Justice Bright then decides it. And that leads to, obviously there are other points, but that leads to, in its own right, in a sense, a very big hole in the case. because it gets rid of the whole Transnet side of things on fair presentation basis, together with the other fair presentation points. And these points are made in the permission to appeal skeleton, and there is a ground of appeal that contests the Russian state point, that's ground 20. But coming back to where we are, His Lordship Mr. Justice, Lord Justice Males does not then grapple with whether all of that gives rise to an arguable case that the finding of failure of fair presentation on the Russian state issue should be made against the claimants, and indeed should lead to the setting aside and non-reissue of permission to serve out on Transnet. And that is, with respect, remarkable. So a decision is made on this critical point.
When you say all of that, are you talking about just this part of it, or are you talking about all of your submissions in respect of the abusive process point? When you say...
Your Lordship is entirely right, and I need to be clear, so let me be clear. There are 3 failure of fair presentation points.
Yes.
They are, respectively, the Russian state point addressed by ground of appeal 20, the corporate approvals point for the transaction, which is ground of appeal 21, and the issue of where and what investigation there was and what information there was as to Ms. Mamadzad's residence,
Yes.
which is ground 22. And the 3 of them stack up to the decision not to re-give permission,
Yes.
which is ground 23. Now, abusive process concerns only the points raised in ground 21 in that little run of 4. The Russian state point that I've just been
Yes.
dealing with is ground 20, and I have still to come on to Ms. Mamadzad.
Right. So the failure of presentation. Okay.
And of course, my lord, I accept to just run ahead to perhaps your lordship's point. Of course, I accept that one's got to look at. You've got to first look at them individually, and then you've got to bring them together, because the question in the end is: would permission to serve out on Transnet have been refused and not reissued? And then, as to Ms. Mamadzad, would an order for alternative service still have been given?
Yes.
I accept all of that. But our point in this application is that there are difficult and intricate issues relating so far on Transnet to both the Russian state point and the corporate approval point. And His Lordship, Mr. Justice Males, did not grapple with those issues.
Just on the, just looking forward a bit on this, as I understand it, from looking at paragraph 571(1) of the judgment, which is on page 256.
Yes.
The judge there is dealing with the question, should I anyway grant permission?
Yeah.
And he focuses only there on the September 2023 documents. Is that right? Oh no, he's not.
No.
He's talking about that's the ex parte in general, is it?
Yes.
September
So
2023.
So in 570, my lord, you see there are 2 decisions. One as to service out,
Yeah.
and the other as to
So
service by
September
alternative
2023 was the ex parte on the.
That's right.
Yeah.
That's
okay.
right. And so the decision to serve out, to give permission to serve out, was made in September 2023.
Yeah, I see.
The decision to permit service by alternative means was made in May 2024, in a separate year. Is that the
Yeah.
answer to your lordship's
Yes, it is. Sorry, I slightly took you out of your course. So you say, well, there are two separate, in relation to
The Transcript side, which is the
Transnet, there are
first of
two
those.
separate heads, as the judge has put it, of unfair presentation or
That's correct.
failure to make fair presentation.
Yes.
And then he deals with the impact of those two in 552, is that right?
That's right. Underground. So he finds a failure of fair presentation on the Russian state point, a failure of fair presentation, a culpable failure of fair presentation on the corporate approvals point.
Yeah.
That leads in the ordinary course to the setting aside of permission. There is then an application, it's all dealt with, I suppose, informally, but there's then an application to reissue those two permissions. And at the passage your lordship has just taken me to, that is a discretionary question, and he declines to exercise his discretion to reissue, which leaves the position that permission to serve out has been set aside, and that means that the claim against Transnet is gone. And as to Ms. Mamadzar, that the decision to permit service on her by alternative service is set aside, and that leads to that part of the claim against her being gone, she being separately a defendant on the Festa conspiracy, which stands or falls on its own merits.
Yeah.
Now, so I was working through, I had really had dug into the substance and was working through the fair presentation point. I should also, though, deal with fair presentation as to Ms. Mamadzar. And can I do that? And then I'll come back to ground 23. So, a separate issue as to fair presentation on Ms. Mamadzar arose. It's dealt with in the judgment at 554 to 561 on page 253. It's the subject of grounds 22 and 23 and is addressed in the PTA skeleton, the permission to appeal skeleton, at 255 to 266.
Before you do that, I'm so
Yes.
sorry to go back on something. So far you've presented it as self-evident that the judge can only deal with fair presentation points which are raised by one of the parties. Now, supposing that a judge has heard an ex parte application and knows that he's made a decision on a particular basis, and then at the inter partes is put on a completely different basis, is it really the case that one of the parties has to take the point, or can the court say, well, this is about the administration of justice, I consider that I was misled?
Your Lordship, in a sense, is right to bring me up on this by putting to me that I have presented it as self-evident on that point. And it may be that is in substance what I have done. I don't mean it in quite that as simplistic a sense. My submission was that in the ordinary course, in these courts, in English courts, fair presentation issues are decided because a party complains of a lack of fair presentation, obviously it having consequences, but a lack of fair presentation, and the court then decides. Ordinarily, the court does not embark on a roving inquiry into the question of fair presentation. That begs the question as to whether it is nevertheless open to the court to embark on either a roving inquiry, but that's obviously to put it too strong, or at any rate, such an inquiry in the event that an issue is brought before the court that triggers that particular train of thought, if nothing else. At a minimum, I would say that if the court is going to do that, it must make plain, it not being an issue in the argument, it must make plain that one of the issues it's going to decide is whether or not there is fair presentation in that respect. And that was not done on the Russian state issue. But I do say that it is nevertheless right to know that ordinarily the court doesn't do that. And so in the abuse of process context, if it was an abuse of process, it would never have got there. And that is a proper issue to raise for analysis upon appeal. But I do accept that I can't go so far as to say that it is, in some more fundamental sense, simply not open at all, ever, to the court to raise issues which the parties haven't put before. I, of course, do not say that.
Yeah.
I'm trying to put it fairly.
No, that's a very fair answer. A second point on that is that I think I've detected that Transneft have suggested that in some way they did raise this issue in their skeleton argument.
The Transneft notice
So
is, sorry, so what we need is the miscellaneous bundle. If you want to find my miscellaneous bundle, I will also turn up. And Transneft points on the miscellaneous on this are in tab 19 of the miscellaneous bundle. And I think what your lordship will be referring to is paragraph 22 on page 87. But I'm not guessing. Does your lordship see paragraph 22?
yeah, I'm just looking.
Now the substantive points are made in 1, 2, and 3, and then over the page at subparagraph 4.
Oh yes.
It is said, well, there's not a procedural irregularity. But I don't see any, or at least I didn't see anywhere here, the suggestion by them that they had contended for it in the hearing. I hope this is the passage your lordship was thinking.
I thought that they said, maybe it's in their other document.
Their other document will be in tab 12. Also of the miscellaneous bundle. And full and frank disclosure is in paragraph 9. And they do refer at the on page 49, toward the end of the first continued paragraph.
That's it. That's what I was thinking of.
So what
they say
is,
it was
was
made
unsurprisingly not on the issues, the list of issues finalised before, because the concession takes place at the hearing, and of course I accept that. But there was another hearing in November, and they simply say, well, the judge was entitled to do it.
But they say it was made, the point was made, they say, of one of overall significance in the first paragraph of their skeleton, with complaints stressed orally in opening.
Lord, I confess I did not see that, and I must take that point and check
Right.
it. But it certainly is not one of the issues that were put up for decision on matters of fair presentation. And I will have to get for you what that paragraph said.
Right.
But I will do
That's
that.
what I had in mind.
And that's what you had in mind, and I will ask those assisting me to look at that. Can I turn to Ms. Mamadzar on fair presentation? Ms. Mamadzar, I'm completely conscious of the extent to which I'm behind time on your lordship's injunction, and I'm seeking to do my best to
Well, we've asked you any questions.
We have.
Fair presentation, as to Ms. Mamadzar, is about the application for not for service out, but for alternative service. And just as to the chronology, what happens is, in September 2023, she, along with others, is the subject of the permission to serve out decision. But she is not served because she can't be found. And in January 2024, there's an application for an extension of time, which is granted. And then in May, after further information is found, there is an application for alternative service, and that's when the permission to serve by alternative service is given. She is then served by alternative service, and in August files, I think it's August, files her evidence in regard to the coming hearing at which jurisdiction and everything else is in issue, and takes a point as to fair presentation in regard to where she's been living. Does also have that essential chronology.
Mm-hmm.
It's dealt with in the judgment at paragraph 554 to 561. It's grounds 22 and then flows through into ground 23 of the grounds of appeal, addressed in the permission to appeal skeleton of 255 to 266, and in the skeleton for purposes of today in paragraphs 35 to 36. Now, there is a degree of factual detail. What I'd like to do is just stand back from it and summarize the factual detail and then get to the assessment of its consequences so that it doesn't get confusing. And the essential chronological underlying facts I understand to be these. Previous conspiracy proceedings had been issued in the BVI, and attempts, she was to be a defendant of those, and they were attempting to serve her out and unsuccessfully trying to find her in Russia. And as at September 2023, when this application came, this case came up for permission to serve out, the claimants thought she was at an unidentified place in Russia. And so if your lordships wish to see the evidence for that, it's Mr. Bushel's first witness statement and the extract in Supplementary Bundle Tab 6, page 51, paragraph 404 and 418 to 420. And his supplementary witness statement attaching some news articles suggesting that she was in Russia, which is Supplementary Bundle Tab 10, page 115 to 127. So that's as a permission to serve out state. Come the extension of time application in January 2024, there had been no real progress. Between the extension of time application and the application for alternative service in May, the claimants found on the internet a Google review related to a hair salon linked to an address which was known or suspected to be Ms. Mamadzar's email address. And that in turn led to further investigations, and by April, they had found an address in Vienna and applied for an order for alternative service, which was ultimately granted. The point of alternative service at that stage being, which is what she complains about, is that it meant that instead of being served via the Hague Convention, running through the delays and processes that it requires, she received service much more quickly under the alternative service order. And those facts are set out in Mr. Bushel's 7th affidavit, which is Supplementary Bundle Tab 21, page 1567, and his 3rd witness statement, Supplementary Bundle Tab 23, page 161. She then files her evidence for the jurisdiction hearing in August. And fundamentally, what she says is, I was always living in Vienna, that's the first point, and inspection of the Austrian Vienna registry would show that. But she adds to that, Mr. Magomedov, the first claimant, knew that because I had told him that. And there is then responding evidence to that, leading up to the jurisdiction hearing, confirming that she had been told that Mr. Magomedov, after investigation, confirmed that he had been told that she had gone to Vienna by her in 2019. He'd not known that she was still there. And that is set out in Mr. Bushel's 7th witness statement, supplementary bundle, tab 41, page 254. So that's the essential chronology of the facts that are then dealt with in the judgment. And at paragraph 559 of the judgment, and I'm summarizing a bit, the judge concludes that the failure to have explained that she had at least for some time been in Vienna, that is on the basis, as I understand it, of what Mr. Magomedov had known or had been told in 2019, resulted in an unacceptable lack of candour, and he set aside both the extension of time and the permission for alternative service of the claim against her. And the key points that would form part of permission to appeal, and I appreciate I need to work through the stages in that regard, a permission to appeal application, are fundamentally, and as the skeleton explains, it is with respect entirely obvious that the claimants were trying scrupulously and very hard, firstly to find her so that they could serve her, and secondly to be honest and frank with the court about that at all points. There is another point, which I'll come to, but the really key point against them was the fact that she had disclosed this to Mr. Magomedov. And the effective submission is, or would be, or was, that really does have to be seen in the context of the quite exceptional conditions that are associated with communicating with Mr. Magomedov. There is evidence the case is dealt with elsewhere. He sits in prison. He can't be visited other than by his lawyers. They can't take notes. He can't communicate electronically or in writing. His lawyers have to make appointments to see him, speak to him orally, and then convey whatever he says. And taking instructions from him is immensely difficult. Now, that doesn't change the fact that he candidly accepts that once she raised it, he did remember that she had told him this in 2019, though he didn't know she was still in Vienna. And so, to that extent, it could be said he should have told his solicitors that, and they should then have told the court. There is a second point, which is very late in the day in replying evidence. She produced evidence of a WhatsApp exchange in which it was said that this must have come to the attention of Mr. Shagav Gadziev, who was a key person on the Magomedov side of things. Again, 2019, years before, and frankly forgotten. So, was there a failure to identify that she might be in Vienna? Yes, but that's how it arose. Was that failure one which was so egregious as to result in a failure of fair presentation, a breach of the duty of fair presentation, such that the application for permission to serve her by alternative service should be set aside? In our submission, the argument against that is a compelling one. It was a very harsh decision, if I may say that, with all due respect to His Lordship Mr. Justice Bright. Now, but where does that get to from this application's point of view? In our submission, what Lord Justice Nails did on this as on the others is simply say, well, His Lordship Mr. Justice Bright was in the best position to assess all of this, he having heard all of these applications. And he was entitled so to find. But that is to render an analysis of and finding of failure of fair presentation unappealable. And that has never been, with respect to the approach of this court. And there is authority, and it is cited in the Permission to Appeal skeleton, in regard to this. In fact, a decision of His Lordship Mr. Justice Nails himself in Dermamed Alley in 2025. I'll just give you the reference. It's Main Authorities Bundle, Volume 8, tab 48, page 2301.
Sorry, give us that again. Volume 8.
Volume 8, tab 48, the case is at 2301, and the page is 2306, and the paragraph is paragraph 30, and I'm going to read it to you. And the relevance, or I'm going to read you the sentence, which is a paragraph in which he says, I would draw particular attention as relevant to the present case to the fact that the overriding consideration when deciding whether to continue an injunction or grant a fresh injunction, that's for ground 23 purposes, despite a failure of disclosure, is the interests of justice and to the need to maintain a due sense of proportion in complex cases. And as it's addressed in paragraph 250 to 254 of the permission to appeal scheme, we really do say the decision as to Ms. Mohammadzad and indeed the others, one does need to have a sense of proportion about, but particularly the one as to Ms. Mohammadzad, was a very harsh criticism and decision indeed. And coming back to
Harsh decisions aren't necessarily wrong.
no, that's true, but it remains the submission that one inevitably makes against them. But I completely accept that.
I mean,
The duty of fair presentation.
they're wrong when they're wrong, but they're not.
Well,
They're not wrong because they're harsh. And
in the
I mean, this is a
context of-
serious point. I'm not playing with words here. The judge has clearly an area of discretion, particularly in relation to re-grant, which is the
I
passage.
accept
you've
that that's the discretionary side.
and that's the passage you've just taken to.
I accept that.
And it's a discretionary matter. The judge referred to the relevant authorities in his judgment.
I accept that too.
It went
Of
for
course I do.
Tugachov case, which is a well-known summary of the authorities.
Yes, I'm going to pick that one up in a moment in answer to
Okay.
Lord's question.
And when it came to it, Lord Justice Males was asking himself the standard question, has the judge gone wrong in the sense required for an appeal?
That's right. I will obviously accept essentially most of that, or most, if not all of that. Can I put it in crisp terms and take it as far as I can? Your Lordship is right. Justice Bright cited at paragraph 547 the decision in Tugushev versus Orlov. There are obviously a whole number of such decisions. It's just one. But it is one that is commonly cited. If your Lordship need that decision, it's at Main Authorities Bundle Volume 7 at tab 39, page 2034. And at page 2037 of that Main Authorities Bundle, the critical paragraph in the decision of Ladyship Mrs. Justice Carr, as she then was, in that case, is in paragraph 7. And particularly, she said various things, a long paragraph with lots of Roman subparagraphs, but including Roman subparagraph 5 and 6. Material facts are those which it is material for the judge to know in dealing with the application as made. The duty requires the applicant to make the court aware of the issues likely to arise and the potential difficulties in the claim, but need not extend to a detailed analysis of every possible point. It extends to matters of intention and so on. Then Roman 6, where facts are material in the broad sense, there will be degrees of relevance and a due sense of proportion must be kept, and sensible limits have to be drawn. And then explains that and how in complex cases it gets difficult. And the primary question is whether in all the circumstances it's effective such as to mislead the court in any material respect. Whether in Tugushev or in any other case, that's the principle. And we both accept and rely on that, on that principle. As to Ms. Mohammadzad and the attempts to find her, and ultimately finding her in Vienna, we simply say it's obvious that everybody was trying as hard as they can to do it. And one does need a sense of due proportion. And even to find that there was a failure of fair presentation by virtue of Mr. Magomedov not having managed to, one way or another, communicate to Selador out of prison. That first he would have had to first to remember and then to communicate that in 2019 she told him she was going to Vienna, though he knew nothing about where she was afterwards. Just is one does need a sense of due proportion, and with respect to His Lordship's Justice Bright was plainly cross, and but it is harsh, and we do submit that it is wrong, and in particular when it comes to then what is a discretionary question, which is the question of whether to re-grant. We do say there is, for present purposes, a very real argument that the court might interfere in that finding. And then when it comes to His Lordship, to Lord Justice Mayles, now taking all of the fair presentation issues together and grant 23. We say on each of these points there were serious and significant points to be grappled with. And that on a fair reading of the reasons for refusal of permission in ground reasons 10 and 11, they do not grapple and cannot reasonably be understood to grapple with these serious points. And that being so, one has to ask, for purposes of this application, if we are right about that, the question arises, had Lord Justice Mayles grappled with those points, might he have granted, I beg your pardon, would he probably have granted permission to appeal on the fair presentation points? And we say we do meet that threshold. And I appreciate the time. That then cascades the dominance on the NCSP side of things, because had he granted permission to appeal on that, it's plain he would also have granted permission to appeal on abuse of process. And in turn, it flows through to the other points in a way that I will have to explain if your lordships permit me to do so. You may wish me to do it not in dealing with the application, but afterwards, should your lordship decide to hear that. But I could go through the individual grounds to explain how all of that fits together. But I am anxious that after lunch I'm able to address you on the FESCO side.
Of course.
So we'll stop there. Yep.
It's a convenient moment.
Yes. Good.
All rise in
So
evening.
start again at 2 o'clock.